This is the fourth screenshot video, which goes with the fourth posting in the area of civil procedure, and it concerns the topic of discovery. Discovery is a process in a civil lawsuit occurs before trial where by the parties to the lawsuit can learn almost anything they want to learn from the other party. And also there are ways via the subpoena process to obtain information from non-parties, but we're going to just focus on let's say plaintiff and defendant, plaintiff obtaining information from the defendant, defendant obtaining information from the plaintiff. And what I know, the procedures of discovery have grown increasingly more liberal over the years. And one could think that the purpose is to avoid a trial by ambush and to have the best outcome in a trial, should there be one, based on the assumption that fully prepared parties will have the fairest trial. Now, I'm going to talk about specific techniques in just a bit, but first let's just consider what information is discoverable. And really, almost anything, so long as it's relevant to some part of the lawsuit and the information being sought is not privileged. In one sense, it's hard to imagine why a litigant would want information from the other party that's not relevant, but sometimes there's tactical things going on and some game playing going on, so that arises occasionally. But usually what people want is, and the reason they want it is because it is relevant to some aspect of the lawsuit. Sometimes there is information that might be highly relevant to the lawsuit, but it's not discoverable because it is privileged. And privileged information, which is really examined in the evidence course, but it could include doctor-patient privilege, lawyer-client privilege, by way of example. Let me just say a little bit about the doctor-patient privilege. Our client, if we're going to look at it that way, has broken his leg, or had his leg broken, better said, right, in a car accident. And by bringing a lawsuit to recover for the damages uh, uh, resulting from the broken leg, we would be waiving, giving up our client's right to keep medical information within the doctor-patient privilege to the extent that information was relevant to the broken leg and the prognosis of recovery and so on. Okay, uh, that gives us a sense then of how wide open the gate might be for getting discovery. Now, how is it obtained? And I just have listed a few techniques, and I'll talk about them. Bill of particulars, and technically, it's not a form of discovery. It's called amplification of the pleadings, but that's almost a relevant point. But in a personal injury case, plaintiff sues defendant to recover for personal injuries. The defendant, at the very beginning of the lawsuit, is going to serve plaintiff's lawyer with a demand for a bill of particulars. And in responding to that demand, the plaintiff's lawyer will be required to list all kinds of details, or if you will, particulars about how the accident happened, uh, who the plaintiff saw for uh, medical treatment, the types of medical treatment, the time plaintiff lost from work, if any time was lost, all kinds of particularizations, which really have the end result of giving defendant a lot more information about the lawsuit than defendant would have had before looking at the bill of particulars. I'm going to jump over depositions just for a bit. There is something known as documentary discovery. So again, to return to that broken leg case, certainly the defendant would be entitled to the medical records involving treatment in diagnosis and prognosis of the broken leg. If it's a commercial lawsuit, plaintiff is suing defendant for delivering a flawed printing press, by way of example, uh, or there's a divorce case going on. So there are documents relevant to the case. Obviously, in the divorce case, pension information, tax returns, earnings statements, and so on. In the commercial case, copies of the contracts, copies of correspondence between the parties, those kinds of things. Uh, and then I have inspection of things or people. Let's talk about things first. In that printing press case, if the printing press is now in the plaintiff's hand and the plaintiff says it's flawed in some way, certainly the defendant is going to want to have uh, its people, its experts, take a look at the printing press. So we have an inspection of things. Uh, the case could involve a piece of property. Claim might be that somebody used their property in a way to damage another person's property by diverting water flow. Well, we might want to inspect the property that doesn't belong to our client with some kind of an expert to determine the layout or the contour of the land, what was done to it to possibly divert the water flow, and so on. Inspection of people. Let's go back to that broken leg case. In that case, the defendant is going to have the ability to have the plaintiff examined by a physician of the defendant's own choosing. For some reason, in the law of New York, that's called an independent medical examination. I don't think there's anything independent about it because the doctor is going to be paid by the defendant, or more particularly the insurance company that's quarterbacking the defense. And that doctor was chosen in part not because there's anything fraudulent going on or anything wrong that's going on, but doctors have different ways of looking at things. And I'm going to tell you that this doctor has been selected with care because he's the type, or she's the type of physician who perhaps isn't as impressed by different aspects of the injury. But in any event, that's an inspection of a person. Now, the discovery process is also going to be very useful, not only to allowing the parties, excuse me, to prepare for a trial, but I think a lot of lawyers who do this kind of work will tell you the discovery process also gives the lawyer to size up the relative strengths and weaknesses of her client's case and the opposing client's case. And I think what most attorneys feel, let's say in a personal injury case uh, where there's a significant injury, uh, the case might not even be ripe for settlement without first the parties having gone through all of the available discovery. So discovery sometimes, I think, helps not only the parties at trial, but it helps the parties to assess where they stand in the case, and thus can be very useful in terms of arriving at a settlement. I said a few videos ago, I'm doing this all in one day for the civil procedure postings, that we wouldn't be talking about trial, but what I will do after we get through criminal procedure, which will be next, I will probably have some kind of a take on a trial that I may just tag on to the last criminal procedure posting. But For now, we've completed our looking at the typical events in a lawsuit, which I am going to also tell you gives us an insight into civil procedure. Thanks.